SJC-11761, Commonwealth v. Eric Cotto, Jr.
Good morning, Ms. Jacobstein. One moment. Welcome back.
It's good to be here.
Thank you. All right, you may begin. Thank you.
Good morning, Your Honors. Today, we are requesting a conclusive presumption of egregious misconduct in this case and in every case where Farag was the chemist on the certificate of analysis. A conclusive presumption is warranted here because there is a nexus between her misconduct and every sample that she purportedly tested.
You mean she might have stolen some of the stuff?
She stole some of it. I think that we have presented evidence that she dry labbed some of it.
Where's that?
Yeah.
That is in
This case.
It's in one of the exhibits. I don't remember the exhibit. It's in my joint record appendix at page 200.
But she said if she did any dry labbing, the evidence might suggest that it happened at the Hinton lab, not at the Amherst lab.
You're making that assumption based on a reference to the fact that she was doing a lot of testing. Is that correct?
Right. So what we're saying is that there is evidence of the dry labbing while at the Hinton lab. We don't have her numbers for the...
Is that the sole evidence, the fact that she was...
Of dry labbing?
Yeah.
Yes, that's all that we presented
Just
on
that she worked there and did a lot of stuff?
Well, and more than Annie Dukin from some months. She
Well,
did.
early on. I don't know what Annie Dugan's track record was in terms of what was going on in 2004.
Based on...
evidence before this judge.
Before this judge, her numbers were higher than Annie Dukin's.
Yeah, but
At one point.
At the
11 years ago.
At the point that they were both at the Hinton lab together. I don't have Amherst
The
lab
one-year
numbers.
overlap?
Yes, Your Honor. And probably not even a
And so
full
that's
year.
your evidence of dry labbing?
Yes, Your Honor.
Okay.
But it's government misconduct, and
Is there any evidence that there was dry labbing done at the Amherst lab?
there is not direct evidence.
indirect?
Your Honor,
No evidence.
well, what there is there's proof that starting in 2000, she used drugs in 2000.
In 2000,
We
she
know that
used
she
drugs
did.
on one occasion. That's the evidence.
And then we know that starting in 2012, she was using drugs.
Well,
And the court
when
found
you say drugs, we know that she was using cocaine.
she was using cocaine in the car that was searched. There was something that tested presumptively positive for heroin. It ended up not being heroin, but there is also the possibility that she was stealing heroin and putting in fake heroin. Why else would she have fake
The car
heroin
that was
in her
searched
car?
when she was arrested? Is that what
Yes, that was part of this car search, and that was before the judge. There is also, but this isn't the only evidence against her. There is also other circumstantial evidence that she had been doing this much longer. There were those articles that were found in her car that she had printed out in 2011.
Well, the judge discounted those as a matter of fact, didn't he?
The judge did, and we're arguing that that was an absolute abuse of discretion. The judge only looked at evidence of retesting. That was the only thing that for him that was sufficient to prove misconduct. Nothing else was sufficient. And that was an abuse of discretion to require proof of retesting since the Commonwealth
What do
didn't
the
do anything.
articles prove? What do you say that means?
The articles prove that she was interested in what would happen to someone when they stole drugs from their employer and got caught. One of them,
What do you take from that?
she was stealing drugs from her employer and was afraid she was going to get caught. So that's what I take.
Infer that she was stealing because she had the articles in her car.
Absolutely. But also, in that same year, so that was, those articles were printed out at the end of 2011. Further buttressing that argument is the case of Commonwealth versus Berube, which was heard at the same time as this case.
Is that the OxyContin one?
No, that is the Carter case, which actually predates that. But the Berube case is where the officer testified that the cocaine did not look the same anymore as when he had arrested, when he had seized it. And the court found that while there was no proof of retesting, so we don't know, this testimony was very similar to the proof of to the testimony regarding the retesting that actually was done. Basically, that it looked like she probably tampered, and there was reason to believe she tampered in this case. That's not what he found, but basically said they were comparable. So now we're back to...
And did Berube get a new trial?
He did, but he would not because of that. He got it because he went to trial. The people who went to trial got new trials.
So what is the principle here? I mean, the testing here was done in 2007.
Yes.
Even if you're right about the articles, those were found in 2011. So what is the governing principle that you ask us to apply?
The governing principle I am asking you to apply is that the government does not get to benefit from their total lack of doing any investigation, and that the burden of this should not be on Mr. Cotto or any other defendant when they have not done any investigation into this. This was a person under their supervision doing this while she was on the job, and we have proof of misconduct predating Mr. Cotto's testing and Mr. Cotto's plea, and near the time of Mr. Cotto's plea, and then post-dating it as well. They don't get to abdicate that responsibility and then come in here and argue that, well, you didn't prove it, especially when...
But they did an investigation. They brought charges against her, and she was convicted. What kind of an investigation do you say they should have done?
They're not required to do any investigation, but if they're going to do it, if they're not going to do an investigation, they can't.
No, my question is, what kind of an investigation do you say the Commonwealth should have done in this case?
They should have done an investigation into the timing, the scope of her misconduct. They should have looked at...
They should have done the same thing with the Amherst lab that they did with the Hinton lab?
Absolutely.
And have a David Meyer from the western part of the state and that? Is that what you're saying?
Yes, they should have. They should have cared. This wasn't as big, and Ms. Farrak made no admissions, but the stuff that was found in the car was pretty damaging, and so that in and of itself would have provided a basis to
But it's a totally different kind of case. In the Dukin case, Dukin was, at least her misconduct was at least inferentially advancing the cause of the Commonwealth to increase the prosecution of criminals. In this case, there was nothing that was attributable to the Commonwealth. She was not her misconduct was not attributable to the Commonwealth.
I disagree. It was attributable to the Commonwealth because it stemmed directly from her duties. She was doing it during her duties as a chemist. She was under the supervision of the Commonwealth while she was doing it. I mean, very lax supervision, as the judge below found, but nevertheless, she was supposed to be supervised by the Commonwealth. And the misconduct in this case undermines the reliability of the testing. She was, evidence tampering, and she was using drugs on the job. But also, I think big picture, the effect of her misconduct is what matters, not the reason for it. The fact we've got two chemists who were tampering with evidence, two chemists who were dry labbing. I recognize that she was dry labbing at the Hinton lab, maybe not at the Amherst lab, but doing the same thing. For the defendants, the result is the same.
So you're saying it doesn't matter why she did it. She could have been doing it to help the defendants, and that wouldn't have mattered.
Right.
She's the government. She's a government employee. She's part of the prosecution team, and that's what you're saying.
That's what I'm saying. I'm saying that right, and she was doing it as part of the team. I recognize that whether it's an individual unlawful scheme is something that this court considers, and we're not saying that somebody else was in on it. But what we are saying is that it's also sloppiness on the part. I mean, to the extent that if we're looking.
So a police officer steals money from the drug dealers that he or she arrests. Right? So finds whatever the drug money is, takes 50% of it, turns the rest in, or maybe none of it in. Does that mean that every drug arrest that the officer ever made, there should be a presumption of government misconduct?
No, because if the officer's taking money from you, you know that. So you can bring that to their attention. This is something that you have no way of knowing about.
You have no way of knowing about?
We have no way of knowing what her misconduct was in these.
Well, how would we know what the officer's misconduct was, except maybe he got caught a couple of times?
The defendant would know. The defendant would know that there was misconduct there.
I suppose you could say, that's not the same cocaine you took from me. It's the defendant's stuff, whether it's his money or his drugs.
Well, Your Honor, there was evidence that 302
I had a lot more drugs than that when I was arrested.
There was evidence that 302 drugs samples came back from the Amherst lab as negative in 2012. I don't think that we can say with confidence that everybody knows what they're carrying around. But I think specifically when you know that there's misconduct, on your case, you can argue about it.
Help me to separate this case from the next case, which is Ware. You say that the government did not conduct appropriate discovery. Did you request discovery in this case, which was denied? I know in Ware that was the situation, but was it here?
In the Cotto case, there was a motion to subpoena Sergeant Ballou. And with that subpoena was everything that he had. Or everything that was part of the investigation, and that was later somehow limited, it's very unclear to me, to just what he had. In the Rodriguez case, and what I've kind of found through going through these files is that people were somehow relying on other people, but that was Attorney Ryan's case. And he filed a very extensive motion for discovery for this, and in that case, he asked for information regarding third-party knowledge, and there was also an attempt by defense counsel to view the stuff from the car, but and the Commonwealth, the district attorney's office was fine with that, but the attorney general's office put the kibosh on it and said no.
But did Cotto ask for discovery, which he didn't get?
Weren't all the cases consolidated?
They were all consolidated. I don't know that he made a separate request. I believe he was one of the people who was his attorney was one of the ones scheduled to go view the stuff from the car, but I don't believe that he made a specific discovery request for it. They just had a discussion, well, work it out, and then the government said there's nothing to see here, and so it got dropped.
And with regard to the consolidation, what pragmatically did that mean? Was the view that if it was asked for in one case, it was asked for in all?
Well, that's kind of how I viewed it by viewing all the evidence. I mean, because I went and looked through all the files. There was a motion to quash the subpoena, but the response to that was only filed by one attorney. But everyone was relying on that one attorney's objection to the motion to quash.
Was it a court? Did Judge Kinder order I don't remember how many cases were grouped, but did he order those 6 or 8 cases to be consolidated for purposes of this multi-day hearing?
He consolidated the evidentiary hearing. There was to be a joint evidentiary hearing between there were 16 cases, 15 defendants. One of my clients had 2 cases. And what he did was he kind of put a couple of attorneys in charge, Attorney Olenoff, who had Mr. Cotto's case, and Attorney Ryan, who had Mr. Rodriguez's cases. And they did most of everything went through Attorney Olenoff and Attorney Ryan, and they made the motions, and they did most of the examination.
So it was sort of an informal joint defense kind of thing?
Right, and anybody else who wanted to get up to ask a question could, but really they ran the show, and everyone else, everyone at the end argued how it affected their individual client, or maybe they missed a point, but for the most part, it was just, we're all in this together. Thank you.
Good morning, Your Honors. May it please the Court, Catherine Robertson on behalf of the Commonwealth. And we are here arguing that this case is different enough from Dukin that there should not be a presumption that in every case that she touched, there was misconduct for the entire time that she was employed in the Amherst laboratory. And I can see you're looking to ask a question.
Sorry. What I wanted to ask was I understand that your office had 4 indictments, or anyway, 4 cases that you pursued against her. But is there any explanation of the dramatic difference in the scope of the investigation by the Attorney General or anybody else? I mean, not necessarily your office, but...
Let me, first, it wasn't my office in Hampden County that brought the cases against Farrak because that was Hampshire County. The laboratory is Amherst, and the misconduct occurred, in Hampshire County.
Sorry.
That's a minor point. The cases were prosecuted by the Attorney General. and so standing here, I can't tell you exactly what the thinking was on the part of the Attorney General. I will tell you that this is really a much more limited situation, just in terms of impact in the number of cases. And I say that because in the Northwest, it's true that this laboratory was set up to analyze cases from the 4 western counties, but there has only been one motion brought for a new trial based on misconduct by Farrak in the Northwest District Attorney's Office, which covers Franklin and Hampshire County, and there have been a total of 5 cases where there either will be, one case where there is going to be a motion for a new trial based on Farrak's misconduct out of Berkshire County, 2 cases out of Berkshire County where the motions for new trials were withdrawn, made and then withdrawn, and 2 other cases.
But is that the measure for an investigation? My recollection in the Dukin matter was that it began with just a handful of things. And then it was only as a result of the sweeping investigation that the depth and breadth of the problem became evident, and then motions were brought. I mean, unless you know the problem, how do you, I don't know that measuring the number of times it's been raised
Well, I think that
is the correct measure here.
Well, I think that is a measure, but in addition to, let me say that in addition to, whatever the Attorney General's office did in connection with prosecuting Farrak, the judge held this 3-day evidentiary hearing, and I would refer the court to the Del Marter case, which is the case out of Washington State, where there was the analyst who was stealing heroin. And if you look at the investigation that was conducted in that case, an appeals court referred the case to a retired judge who held an evidentiary hearing. He heard testimony from the 4 co-workers of the bad actor who was stealing heroin. The bad actor apparently testified as well. We do not have a statement from Farrak in this case, and that is a difference between Dukin and Farrak. She was more forthcoming. But that was the investigation that was conducted in Del Marter, and the retired judge made findings based on the testimony that he heard. Now here, the judge heard more extensive testimony. He heard testimony from the Massachusetts State Police, a member of the audit team. A large part of what was, looked at in the Hinton investigation was what were the operations of the Hinton laboratory like? What were the deficiencies in the operations of the Hinton laboratory? Well, Judge Kinder heard that kind of evidence from Kathleen, and I don't remember her last name, but she was a Massachusetts State Police, a member of the audit team that looked at the operations in this laboratory. So there was quite extensive testimony from her. There was testimony from another Massachusetts State Police member who had conducted audits, an inventory of the samples. So Judge Kinder heard from him. All the samples were present at one point in time, 4 samples are missing at another point in time. He heard testimony from all of her colleagues at the laboratory, as extensive as, the defendants saw fit to hear. He heard testimony from a defense expert who had reviewed all of the documents that were turned over. And I think then he heard testimony as well from the 2 chemists who had retested the 4 samples that were retested. So that was the information. That is a form, I think, of investigation.
There's a concept, and I don't even know if it applies here, but of random sampling. We do it with voters. We do it with a lot with consumers. Was there any attempt to conduct a random retesting of the analyses that Farrak had done in the 10 years that she had worked at this lab?
No, you're right.
And is there?
Yeah.
I don't know if it should have been done that way, but do you know if any consideration had been given to doing that, and why it had not been done?
Why it wasn't done? Well, I don't think I'm really in a position to answer that question. I will say I do not believe that it was done. I think that there are some problems with trying to do it, and that is, for example, in Mr. Cotto's case, the samples were tested in 2007. The case was disposed of in 2009 by guilty plea. The sample that was the basis of his conviction by plea has been disposed of, and that happens in the normal course. There is a process for the destruction of narcotics. In the more recent cases, I think that the samples still exist, and I will tell you that the Ware case that we're going to hear next, the sample that was submitted in connection with his 2009 indictment does still exist. And one of the suggestions that the Commonwealth has made is that at least as to the let's say we have we have the judge's finding that there's misconduct in 2012 and going forward. And let's say that because there's some additional evidence that was submitted by Mr. Rodriguez, let's say there's going to be an additional hearing that looks at whether or not maybe there's some additional evidence of misconduct in 2011. Let's say that happens in another case, in Mr. Watt's case or in another case. There's a real prospect that those samples still exist. And unlike the case in Dukin, we will know whether or not she adulterated the sample, because what the findings are, really, with respect to her misconduct, the findings are she tested, she took out of samples that were controlled substances. And I guess I think that's really sort of a fundamental difference. We don't really have evidence here, as we did in Dukin, that she falsified results. She didn't contaminate samples so that she could report a false positive, and she did not fail to test and then report that the sample had been tested, which I think also raises the prospect.
But, true, and it is an important difference, but for a defendant, for example, if she has taken away and put in soap or whatever,
yes,
you can't retest it, obviously.
No, you can retest it. In fact, four of them were retested. No, when I say retested, Your Honor, we will know then whether she adulterated the sample. We will know whether misconduct was committed in the defendant's case. That's what I'm saying.
Do we
it's
know
not
in every
unknowable the way it was. I'm sorry.
Do we know in every case, I know there was a suggestion of this, that the drugs had been weighed by somebody else upon their arrival at the lab?
Yes, they always are. They are always weighed by Sharon Salem. She was the evidence officer. So they're weighed in their packaging. They're weighed in their packaging, the packaging that the police department has put them in. That weight is recorded, then they're put into the safe. So
and that could be compared to what now exists?
It could, but it would include the packaging, and you'd have to, yes, that could be compared to what still exists, yes.
So this is a question that probably is answered somewhere, but I guess what was kind of arresting reading this was it seemed somewhat, I couldn't figure out why 2012 became the cutoff.
Yeah, well, and
that's not so much from Judge well, I mean, it's before that. Why the Attorney General or whoever, the state police, kind of said, okay, we're going from 2012.
The Attorney General's office prosecuted her on the specific cases where the samples were missing. Were missing, really. 4 cases where the samples were missing. That was what they prosecuted. The 4 cases that were, I think, somewhat randomly selected by prosecutors, there was retesting. But there was also circumstantial evidence of, that things had really started to go downhill for her in 2012. And
because of the way she was acting, and
this was the way she was acting at work, and it was noted by all of her colleagues that that she would disappear for fairly extended periods of time during the workday where that hadn't been the case. And this is a small lab; they all work pretty closely together. That she was no longer using the bathroom that the other analysts used, but she was using a bathroom that was more remote. And I think the inference is she could have been going there, to take drugs, and that generally. Her productivity declined. And just briefly on the dry labbing, I mean, the evidence of dry labbing at the Amherst lab, there's testimony by Jim Hanchett that her productivity is very much in line with the productivity of the other chemist too, which is Rebecca Pontes. I mean, I think there are 2 ways you could maybe show dry labbing.
So they were also in line with Dukin's?
No.
No, they were in line with Dukin's when she was at Hinton.
Well,
how do we know that they're all not dry labbing at Amherst?
There's no but there's simply no evidence of that, Your Honor. There's no evidence of misconduct by Ms. Pontes, and no evidence of misconduct by Mr. Hanchett. And the other, I think there are sort of 2 ways you could look at that. You could look at you could look at productivity, and Sharon Salem, who was the one who assigned the analyses, was not asked the question by the defendants when they had her on the stand, and that's because she had already told the state police their productivity was right in line. The other way you could look at it was to look at the spectra that, are we seeing exactly the same result across a whole number of cases? Well, the defendants had an expert who could have done that comparison. And again, there's no evidence of that. I'm just saying there's no evidence of dry labbing, at least at Amherst. I don't think there's any evidence at Hinton either. Those are just numbers on a piece of paper without any explanatory testimony. But unless the court has further questions, I see.
Thank you.
Thank you, Your Honors.